Welcome, everybody, to another edition of Seattle Angel Conference workshops. These are free workshops offered to help entrepreneurs and angel investors really learn critical information that will make them successful in what they do. Today, we are focusing on the legal side of things. Specifically, this session is called Liftoff, the Lawyer's Guide to Critical Agreements for Startups. This is something that is absolutely important to understand and most often ignored. So um, we have two speakers today. Adam Matherly is a shareholder at Karr Tuttle Campbell and head of firm's emerging entities and venture capital practice group. Adam represents high growth companies as outside general counsel, including financing and mergers and acquisition transactions. Adam also represents venture capital funds and angel investors. Steven Clarke is an associate at Karr Tuttle Campbell and focuses his practice on mergers and acquisition transitions and representations of emerging companies. So I would love to give Adam the floor. And yeah, please, the floor is yours.
Thank you, Leo, and thank you everyone for being here and for introducing yourselves. Leo already gave us warm introductions, and I'm grateful for that. I think I'll just make a comment that our firm, Karr Tuttle Campbell, it's a full service firm located in Seattle. We've been in Seattle for 120 years as of last year, so add one, and and yeah, I head up predominantly the venture capital and emerging entities group. Steven Clarke is one of the attorneys in that group. Steven, is there anything else you want to say about yourself?
No, I tend to split my time between kind of this venture capital, early stage companies and end stage companies. Like Leo had said, I find they inform one another and kind of are important to consider the end point when you're thinking about the beginning as well. So happy to be here and thanks for having me.
Great. Steven, do you have do you have access to video or do you just want to be audio today?
I'll just be audio today. I had some dental work done this morning, so I'll spare you my visage.
All right.
Steven has an emotionless face today, and
Yeah,
Fair,
so
fair,
I'll spare you all that.
fair enough. All right. Adam, the floor is yours. If you need to share PowerPoint or anything else, I think you can and should.
Sure. So I do have some slides I can work from. Will you tell me if this looks right to you? You should just be seeing a single slide.
Nope, it shows me the opposite. It shows me your presenter view.
Got it. How about this?
Now,
Yep.
now it's perfect. Yep.
Got it. Okay. Well, I'll start off on this slide. Really, the thesis here, and I forgot to mention about our firm. We've worked with Seattle Angel Conference and John Seacrest for a number of years. We are a legal sponsor of the events that come out of Mossy Ventures, including Seattle Angel Conference, and we're also the attorneys for Mossy Ventures and act as attorneys for the the individual funds that are formed around these events, the twice annual Seattle Angel Conference events, and some of the other kind of affiliated funds. There's been kind of healthcare centric funds and events through APIS, and more recently some international investment conferences that we've worked with John and Mossy on for at least 10 years now. So we're grateful for the relationship, and I've been around SAC for a number of years. The thesis behind today was pretty loose. It was basically let's talk about the documents and agreements that founders really ought to know about. We'll be working with frequently, especially in kind of the early years of its existence, and so today will be a little bit of a grab bag. I think it'll be much more interesting, and my preference in these workshops especially is to kind of engage with you as you have questions. That's worked very well in the past. If you want to throw them into chat, or even, you know, raise your hand or something. And I'd love to address questions that way. But I think this will be just kind of a conversation around kind of the you know, the legal side of things for the first couple of years, what we're generally tasked with as far as kind of initially organizing a startup company, and then maybe just some practical considerations for where to find documents, how to modify documents, what should you use attorneys for versus what should you go try to maybe do yourself, if you're trying to manage your legal budget efficiently. So all of that's kind of wrapped into today, hopefully, and so that's what we'll start. So
Perfect. Let me just interject that I really encourage you all, if you haven't done so already, change your name in the participant menu with your name, your company name, and location. I think it will help people orient where you're at and what you're doing. And then if you so desire, you can put in your LinkedIn contact into the chat so that when you save the chat at the end of the workshop, you actually have contact information of those people who made an impression on you. I always say network is your net worth. So build it from these free workshops is a great way to find people who are genuinely serious about doing the right things. And also, if you put in, as Adam said, if you put in questions into the chat, I will call on you first. So your questions will be answered first. So that's your encouragement to be participative inside the chat itself.
yep.
All right, go ahead. The floor is yours.
Okay, so you've met us. This is what Steven looks like when he's on camera, and this is what I looked like 2 years ago. There you go. So starting with kind of the basics, what are we first talking about with a founder who's talking with us about forming their company, and we're kind of outlining what we're going to be working on initially. And this is kind of just the initial punch list here. What we need organizational documents to get the entity in, you know, whatever entity choice we're working with here, whatever jurisdiction. We need something to go and form this thing, and then to put some structure around it. So it's quite easy to go and form an entity, but to actually put together the pieces of how is this owned and managed requires additional documentation, and that really some care should be taken to do that right. Part of that organizational doc set will include kind of the initial equity issuances to the founders. That's an important piece that is too frequently overlooked, and so we take care of that in kind of the initial document set. There's documents around, I mean, especially with every company should be thinking about this, but especially kind of tech heavy, tech sensitive companies need to be thinking about the intellectual property assets of the company, and how to get the assets into the company in the first place, and then how to make sure that anybody who's providing services or intellectual property assets is properly kind of conveying those so that they're owned by the company, because that is the thing we want to grow in value. A large part of the value of these early stage companies is wrapped into its intellectual property. So it needs to make sure that it owns what it thinks it owns. And then kind of later in the presentation, I mean, each company has its own needs with respect to its vendors and its customers. But we'll talk a little bit about kind of service provider agreements, and then customer vendor agreements, and what we're typically asked to prepare, and how clients are using those types of forms. And then just as kind of some why are we even talking about this? Certainly there's a handful of motivations. One is to create some certainty for you if you're going to be raising money from investors, if you're going to be asking other people to forego other jobs and come work for your company. I mean, it behooves you, and really you're required to go and make sure that things are done right as far as the organization of your entity. Avoiding disputes, I suppose, is an argument for entering into any clear legal agreement. Everybody should be able to understand what they're agreeing to. And in the context of organization, I mean, the founder should really have a strong understanding of how their company is organized, especially how it's owned and how it's managed. Oftentimes our first phone call is, I just want kind of enough to open a business bank account is kind of what we'll hear. And I'll kind of flag what those things are. In fact, there may not be a better time. And I was just on the phone with somebody this morning about it, but in general, every bank is different, but you need to show something that the entity was formed. So usually a charter document, a tax ID number, an EIN, which is something we can help retrieve or something you can get on your own. And then a minority of banks may require a business license, or even kind of organizational consents, which show kind of who the officers of the company are and who has authority to open accounts. So, and last but not least here, just protecting the company's assets. As you're aware, kind of corporations or limited liability companies, these are beasts which offer limited liability protection. So if claims are made against these entities, at least in theory, people should not be able to come and make claims or pursue the the assets of individual shareholders, as long as kind of the company does a good job of treating the company like a separate entity, and part of that is creating clean, clear organizational documents and entering into legal agreements which show that you're not just using this as kind of an arm of your personal business operations. This is a separate legal entity that's entering into its own agreements in its own name. All right, I'll stop for a minute, and Steven, do you want to kind of take us through initial formation and incorporation types of documents and materials?
Of course. So one of the first things, well, actually the first thing that you'll need to do when you're starting your company, starting your entity, is file a formation document with the Secretary of State in the jurisdiction that you'd like to form your entity. Typically for high growth companies, that's going to be a Delaware C Corp for quite a few reasons. I mean, that's what investors kind of expect to see. That's where corporate law is a little bit more established. So we see a majority of the companies that we form being those Delaware C Corps, but there's also Washington corporations, limited liability companies. It's really a case-by-case basis. But once you've decided on your entity form and the jurisdiction you want to form it in, you'll have either the articles or certificate of incorporation, depending on the jurisdiction, if you're forming a corporation, or articles or certificate of formation for a limited liability company. And I think Trevor had mentioned that he was looking for places that you can kind of do something on your own. This is definitely somewhere with pretty minimal research and pretty minimal landmines that you can take care of yourself to save a couple of bucks. But these are the documents that are actually going to create your entity and build that to move forward. There's a few considerations, like I mentioned, jurisdiction. Typically for this crowd, it's going to be either Washington or Delaware. The form, really a case by case, but like I said, a Delaware C Corp is the typical one that we see. Authorized shares, this is something to consider. A lot of founders don't necessarily think ahead, and they just want to issue themselves, a few shares up front. Why not just authorize 1,000? We'd recommend just, our standard is 10 million, and then you just issue the founders a couple of million of those to give yourself flexibility in the future, and also to not have fractional shares. You can give smaller slugs without having to worry about that. And then tax treatment. So this is something that you should kind of think about, talk to your accountants about. C Corp, S Corps, partnerships if you're an LLC. There's a few different toggles that you can have there, and maybe a couple of provisions that'll end up in the organizational documents, but those are the main toggles and things to do there.
Can I say, Steven, so when I think about kind of the three paths we often see as far as founders taking the steps to get kind of formed and organized for the first time, I kind of see there's three ways it's done. we see kind of the do-it-yourself approach. People will find forms, online, some of which are good, some of which are not good. Founders will use kind of an organizational formation type of service, like your Rocket Lawyers and legal Zooms and things like that, where people will use attorneys. And I think it's fair to say that those that use the first two paths, we tend to spend, like, by the time that they come to us, usually in connection with like a first financing, for example, like the first time they really think, wow, I really ought to be talking with an attorney, we spend an awful lot of time kind of cleaning up things that they hadn't considered when they were either doing it themselves or filling out the fields in a legal Zoom type of service. And so there's certainly room for the other two paths. But I would say if you're taking one of the first two paths as a founder of a company where you're going to expect to raise some outside capital, I would expect there's kind of some upfront legal time, some legal time from attorneys that you engage later on spent looking at what you've done prior and probably cleaning them up to a certain extent. I don't think I've ever seen a set of legal Zoom documents that we didn't have to modify or correct in some way. So I thought I'd mention that, and keep going, Steven.
Yeah, of course. I think the next slide is probably. And then, like Adam had said, the forming is a pretty simple part of the process. You file something with the Secretary of State, but then you need a document to kind of establish the governance and the management of that entity, and that's where these come in. So you have your LLC or your operating agreement for limited liability companies, or you have bylaws. And these documents vary in length, but typically it's just establishing kind of the rules and the guidelines for how your company is going to be governed and managed. They kind of are the documents that are going to grant or limit authority. So some thought goes into whether or not you will have a board of managers, a board of directors, depending on your company, how many people are on that board, and what powers and authorities that board will have. It'll appoint officers or kind of outline officer positions and the authorities that those positions will have. So think chief executive officers, your secretary, your treasurer, et cetera, et cetera. And then it can also set voting thresholds for important actions. So there's statutory defaults depending on where you form, on how many of your shareholders or members or board members need to approve, say, an exit or incurring a large indebtedness. So say opening a line of credit or something like that. That's where you would set those things forward here. So when you're building these out, you want to be thinking about who should have what authority. Do you want your board of directors to be 2 people, 3 people? Who should have to agree to take major corporate actions? So do you want just a simple majority, so 51% of your shareholders to approve something, or do you want something larger, say 2/3, like a super majority, to have an exit? And this is all going to be kind of case by case to your founder group and your shareholders even forward. And then also, like we mentioned before, considering dispute resolution mechanisms. So this is where it's good to talk to a lawyer and kind of think things through, because you may have, say, 2 founders and you're agreeable now and you agree on your path in the future, but you don't want to end up in a position in a year or two where maybe you have differing views on the direction the company should go, and you can kind of veto each other's vote. So you're stuck in a deadlock and have no path forward. This is where it's good while you're on good terms with your founders to kind of establish ahead of time how you're going to kind of sort those things out and solve those problems as they come up. Adam, do you have any other considerations you want to add to that?
No, I think it'll kind of tail into the next slide, because I want to be clear at some point here, kind of what do we consider the organizational doc set? What are we typically providing to startup clients? But let me start by saying, I mean, one of the key ingredients, I mean, we've talked about kind of a charter document, something that gets you, something that gets the entity actually formed for the first time, and that's filed. It's done on a state basis. So you need to pick kind of what entity type you're going to be, and you need to pick kind of the jurisdiction, which state are you going to form this in. and Steven mentioned this, typically because we're based in Washington, we're talking with people from Washington about forming either a Washington entity or a Delaware entity, which is kind of the neutral jurisdiction of choice for startup companies for a variety of reasons. But we'll also speak with founders that are in other jurisdictions, and they have a preference to kind of form in their own state. So it seems like today's startup, it's 3 founders in 3 different time zones, and so geography doesn't mean as much as it did 10 years ago, certainly. So charter doc would be number 1, for corporations, which I think kind of our conversation should be somewhat limited to. The organizational docs also include bylaws, which talk about, the things like how meetings are called, how many directors are, how directors are elected, how they're removed, kind of the formalities of the business, and how the corporation operates are wrapped into the bylaws. And then what I wanted to talk about here was kind of an initial organizational consent. The person who forms a corporation, we label them the incorporator. It could be a founder, it could be your attorney. And the way we do our docs, generally the incorporator goes and appoints kind of the initial directors of the company, so that somebody can take action for this thing that's not your attorney. And for a single founder, that would be, they would be the sole director probably of this new corporation. And now they need to go do a bunch of stuff to put some meat on this kind of empty shell of a corporation. And it does that by an organizational consent, usually where the director is adopting bylaws. It's approving the initial equity issuance to itself and other founders. It's appointing the initial officers of this corporation. It may be outlining who has kind of initial authority or ongoing authority to do things like open bank accounts and sign agreements. What else are we doing? It may approve various forms of things to be used in the future. But those, I think what I mentioned are generally what we try to cover in this. And these are fairly custom. These will vary quite a bit from company to company. The individual sections will be the same, but as far as the officers, it depends on how many founders you have and who has what role. And that's usually a conversation piece between us and the company. So our initial kind of organizational conversation with the company is usually one of our longest conversations, where we try to really understand how they want to be set up from the outset. That's done in the organizational consent. And then just on an ongoing basis, we're often tasked with providing meeting minutes or written consents, which approve certain actions. Certainly anytime that a corporation is issuing equity, whether in the form of shares or stock options or restricted stock awards, RSUs, anything, you should be thinking kind of, okay, what did we go through the approval process for that? And so we're often approached to help make sure that the approvals are obtained, and that's usually done either at a meeting where meeting minutes are kept or via written consents. Certainly the start, from your intros, several of you are either kind of in the throes of startups or considering kind of first financing events. Certainly anything, related to a financing, that's a major event. There's a approval process for corporations. They generally needs to be approved at least by the board and usually the requisite stockholders of the company as well, because now you're issuing some securities that are probably going to have rights senior to those holding common stock.
And typically, this is important when you do go through your first financing. This is one of the main diligence points that investors will go through. They'll want to see that, members of the boards of directors were appointed properly, or managers of your LLC were appointed properly. They're going to want to make sure that anything that's on your cap table, so any equity issuances were authorized to be issued, or any outstanding convertible notes or safes or previous issuances have been authorized by the board. So this is where it's important, because it's basically the written evidence that the proper authorization was used.
Great point. I mean, that really ought to be on slide 1. I mean, part of the reason we're going through this is that there's a handful of times where your corporate documents, your company documents are going to be subject to pretty intense scrutiny. Certainly any major financing event where investors are doing diligence. If you get to the level of needing kind of regular financial audits, that would be another time. And then, on some sort of exit event, an acquirer is gonna look at everything. And what they all would love to see is a very boring folder in the data room that has a clean set of the corporate documents. And so that's what we try to accomplish for our clients is very boring, clean, and comprehensive documents that don't invite a lot of questions.
I like that I love how you said it, and I agree with you. It should be in the first in your first slide. Is the mission of every founder is to create a clean set of boring documents that actually work before as they start their company. I think that's a beautiful way, and I would say a clean, professionally made and inspected set of boring documents. I love it.
So Steven and I always believe that looks count to a certain extent. And so we do. I mean, I think that's part of it too. Professional looking, and professionally prepared is our preference. But no matter kind of where a company's at, that's where we try to get them to. After we've helped them. So let's see, Steven.
Yep.
I think this is you.
Yep. So, I mean, in the same vein, clean set of boring documents, something that's usually lacking that I see quite a bit of is the equity issuances. It's something that's very important, but often overlooked, as Adam had mentioned, especially in, friendly founder groups where you have a lot of handshake agreements and maybe you've been talking for quite some time. But it's really important to make sure that it's documented who owns what portion of your company. It helps avoid disputes later on. It sets expectations from the get-go. And also it's going to be one of the main points of diligence that we had mentioned that investors and eventually acquirers are going to look at, is making sure who you say owns the company actually owns the company. So that being said, there's many different agreements that can kind of do this. You'll see all sorts of different flavors. You'll see common stock purchase agreements, restricted stock purchase agreements, subscription agreements, unit purchase agreements. I mean, the list goes on and on, but what they all have in common is they're issuing equity in your company to the founders and to the early service providers. There's a few things that you'll want to think about kind of up front. So vesting considerations. Vesting is when you're issued a set of stock or units or some kind of equity, and that equity kind of vests or becomes yours over time. So the typical schedule that we see is a 1-year cliff where a quarter of whatever you were issued is vested, and then after that, quarterly or monthly, a certain fraction is then vested in you. And common misconception is that it's issued at those times. Typically, it's actually issued all up front, and then it's subject to a repurchase right, where if you leave the company can purchase that back from you at the fair market value that it was issued at, which is maybe a little bit more nuanced than we need to get for this conversation. But vesting considerations, some founders will just issue everything up front, where you just, say there's 3 of you, you just each own a third of the company, no matter what happens, and you move forward from there. Other times you might want to use vesting as kind of incentive to get founders to remain involved kind of through those early stages. So say you're each issued a third up front, but if one of you leaves the company after a year, they forfeit a certain chunk of their shares to kind of incentivize continued input and value for the company. Sweat equity is what a lot of people call this. And that's done through vesting most of the time. Valuation issues. Frequently what we'll see is where there's a founder group where maybe one person contributes cash and the others are kind of contributing services or labor or intellectual property. And that can lead to a few issues with phantom income where you're going to be incurring income tax on large slugs of stock valued higher than you want it to. So you really want to issue these shares at the lowest possible price that you can. Typically par value, a fraction of a penny. And we recommend that you just throw $10 into the company for your stock up front, just to avoid tax issues later on. And then in the same vein, 83B elections, this is a term that I think everybody tosses around, but not everybody always understands. And because everybody throws it around, it's kind of a, I'm afraid to ask what that means thing. Simply 83B elections, you're paying taxes on the value of the stock when it's awarded, rather than on the value of stock when it vests. So if you do have vesting stock, when that stock vests is when you kind of incur income tax. So if I'm issued 100 shares and 25 shares vest every year, I'm going to be taxed on the value of those shares when they vest. So if it's worth a penny the first year, it'd be 25 cents of income. If it's worth $1 the next year, it'd be $25 of income, et cetera, et cetera. This is something that is almost always recommended that founders file, just because your stock ideally will never be less valuable than when it's issued to you up front. So you'd much rather pay tax on that $10 for a quarter year company than 4 years later when a quarter year company might be worth $1 million or $2 million, and then you end up paying a bunch of tax. Subsequent issuances can get a little bit more complicated. That's where we usually put in place a equity incentive plan or a stock incentive plan. And that kind of opens up some other options. So issuing stock options, RSUs, restricted stock. But typically we don't see those put in place for some time until you kind of have actual employees and you're issuing them on a regular basis.
So I had two comments, if there's no questions. One is on the vesting. I mean, I think there's kind of the key question to ask. If you're forming a company that has multiple founders, I think you have to kind of be honest with yourself and ask the question, what do we want to have happen if one of these founders leaves? Should they be able to retain all of their shares, or should we have, should the corporation have an opportunity to go recapture, unvested shares or a certain percentage of shares depending on when that person left? And different founder groups do have different feelings on this point. And I'd be curious, Brian, if you're with us and you have audio, what do you typically like to see here? I guess we favor kind of issuing restricted stock to founders where they're kind of undecided on the point.
Yeah, I would agree.
Can you guys talk a little bit more about what restricted stock is? And there are a few questions that people have put into the chat. If you want to take a little break from the presentation, we can answer them now, or we can just keep them until the end.
No, I think now's kind of a good point to circle back to some of these.
Okay, so why don't you answer the question? Just clarify what restricted stock is versus unrestricted, not restricted stock is issuance, and yeah, and then we'll go from there.
This term restricted stock is sorry, I was sharing my meeting chat. It's used to describe a few different things. The way I was using it just now was kind of to refer to stock which is subject to vesting. And really what that means is I'm going to issue, the corporation, not me, is going to issue a whole block of shares to a founder up front. They're going to own them from day one, but the corporation's going to retain some ability to repurchase a portion of those shares if that person leaves within a certain period of time. And the portion that the corporation can kind of recapture falls away over time. And the standard is kind of the traditional 4-year vesting schedule that you hear about, kind of 4-year vesting with a 1-year cliff is still kind of the most common vesting scheme that we see. So if
Just to clarify, I when you're talking about the restricted stock investing, I didn't realize that they were the same thing. But more specifically, I always thought of it backwards, where let's say you're a founder and you get 10% of stock, and you get 5% the first year, and then 1%, 2.5% every other year, right? So in the end of the first year, you have 5%. But what you're saying is the opposite. If we do a restricted stock that way, you do get your 10%, but then the company basically can buy out the percent that you haven't yet vested. So what are the differences here? Are these two different types, or am I misunderstanding the original?
kind of two different types of equity awards, I guess is how I view what you just described. I think you're describing something where I'm granting you a certain number of shares up front, and then I'm kind of either promising you with a handshake or promising you in a document that I'll give you a block of shares later and another block of shares later. It's usually more tax efficient um, to have them awarded, or to have the founder actually purchase the shares when their value is the lowest. And so providing them all up front at kind of the lowest possible value when the company is just formed and doesn't have much in the way of valuable assets other than maybe a business plan. Um, it's it's the most tax efficient way to get those shares in the hands of the founders and early service providers. What you're describing is kind of like restricted stock units, which we're trendy, especially with large corporations for a while. I think Microsoft was famous for using RSUs for a period of time, and that's essentially what I'm describing. I mean, we'll give you, Microsoft's promising to provide you 500 shares, but not all at once. We'll give you this number of shares year one, this number of shares year two. But unfortunately, the valuation is increasing over time. It's never kind of in stasis.
Okay,
Does
thank you.
that make sense, Leo?
It does. So you're saying in the startup world, the preferences at this point is to do uh, uh, restricted restricted uh, grant all of it, and then have the right to buy back some.
Definitely, definitely. I mean, just from kind of founder tax treatment. Um, Otherwise, each of those events, each time they're kind of awarded the stock, they're receiving something that has value at kind of next year's valuation, right?
So it's a headache. Yeah, that's
Yeah,
actually a really important note for everyone. How you structure the equity giving to this founders. Okay, so we have a couple of questions here. Let's see here. Ram said founders frequently don't know if they even have a business worth pursuing. So, in addition to entering contract or opening bank accounts, what are other triggering events that necessitates putting legal documents in place?
fair question. I mean, limited liability may be one. Having a place to kind of house the assets of the business and actually kind of grow valuation is another. But I think, Ram, what you're describing is pretty common. There's kind of a period of time where it's just idea phase, and 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 there may be no kind of entity formed at that stage until they decide, hey, we need to enter into uh, an agreement with an advisor or a software developer. And now we really ought not be doing that in our personal names. We ought to be doing that in the name of some entity. So we're not going to be personally liable, and so that the entity that is the business that we're trying to form here um, has the legal benefit in the title in that agreement. So, I mean, I would say agreements, banking purposes, certainly financing are kind of the common triggers we see.
Great. I asked the question of if you can go over the importance of building a board of directors early on and your experience of documents needed to create that.
Yeah, initial. So there's no such thing as a corporation with no board. It always has a board. And so from day one, after you form the document, the incorporator needs to go and identify the initial directors of the corporation.
Sorry, LLC doesn't need a board, but the S Corp and a C Corp do. Is that correct?
LLC is wonky. There's all sorts of things you can do with an LLC. They can be customized to oblivion. You can have boards on an LLC, but it all comes down to what's in your operating agreement. How does your operating agreement describe how the LLC is managed? And so you look to that to determine whether it's managed by, the members, an individual manager, or a group of managers that forms, a board. And the corporate structure is much more redundant and predictable, and it always has kind of the same, the same three categories of people. It's shareholders that elect directors that then appoint officers to do the day-to-day. And you don't need to look at an operating agreement to kind of know what those three groups represent.
Paul asks, how hard is it to change from S Corp to C Corp? And I would also add to that, how hard is it to change from C Corp back to S Corp? I know the answer, but you can, I'm sure this would be.
Leo, give us your experience. I've heard a lot of my voice today. And
No. I'm not, that's above my pay grade.
We do, we'll have a minority of clients start life as a pass-through entity, whether it's, a single member LLC or something taxed as a partnership for federal tax income purposes, or an S Corp, with the idea being that, individual owners can kind of take advantage of losses early on. And then when this thing either needs to start being financed by outside investors, or actually starts kind of generating some revenue, then we'll kind of turn the switch and be treated as a C Corp, and file the elections to be treated as a C Corp. I really don't see the opposite much in our practice, where companies are starting life as a C Corp, and then converting to S. And I guess, for all of you out there, C Corp in the startup world, C Corp is the tried and true. It's the standard. One reason being S Corps can't issue multiple classes of stock. And, your traditional investors in an early stage, high growth company are demanding something that looks like preferred stock, something that has rights and preferences that, the common stock owned by the founders that don't have. Primarily a liquidation preference, kind of a first right to get your money out first. So that's a major factor. The other is just, tax. There's two layers. There's obviously tax at the corporate level for a C Corp, and then tax when dividends or distributions are actually made out to the stockholders. That sounds unattractive, but for most C Corps in the startup world, those dividends are only going out to the stockholders at some sort of exit event. At least, in the very early stage company. We're a well-sized firm. We're 60 attorneys and have a strong business group, but at some point, we'll have startup clients that at the Series D or E stage may graduate us, and so we don't tend to see a lot of our clients that are startup companies issuing dividends. They just haven't grown to the point where they can actually part with their cash. And that is the thesis for a lot of startup companies. They're not built to spit out cash to the stockholders over the years. They're built to reinvest their money into growing the company. And so
That's great. I did think though the one caveat with the S corp versus C corp, it is relatively easy to go from S corp to C corp. It's really hard to go from C corp to S corp. If I'm correct. So S to C is easier than C to S.
I I'd be I would entertain the argument to the contrary, but I think you're exactly right. I mean, and that's my experience, and that what tends to be more common. If somebody else has a different experience, I'd be interested to hear it. We just don't do a lot of C to S, and I can't think of a time I've handled one.
Yeah, there's no real reason benefit for it, but the problem is, I think my experience with S versus C is that C corp you have double taxation. That is a major piece. It's not just the dividends; is the your profit get taxed as a company, and then you issue salaries or anything else for the founders or people who are working for the C-level executives, which are often founders, and then it gets taxed again. So there is the value there, and the paperwork of the C corp is much more arduous, but not impossible. But yeah, is there a particular time when you see companies, startups graduate from S corp to C corp, or do you suggest that they kind of start their life as S corps, as C corps to begin with?
I mean, I tell founding teams that may have an idea of starting as a pass-through entity and then converting to C later. I mean, if you're going to be attempting to raise capital from investors in 6 to 12 months time, I mean, just start as a C corp. I mean, you're not going to be around long enough as a pass through to kind of recognize the past benefits uh,
Mm-hmm.
from that, and
Great.
you're kind of just complicating your life a bit.
Mm. That's great. Let's see here. Ram also asked, why must one consider alternatives to Delaware, such as Nevada or Wyoming? And I would just add to it, and why consider uh, alternatives to Delaware, Nevada, Wyoming, and why Washington? You know, why would that be still a viable option to go to some other state?
Lots of great companies started in Washington as Washington
Exactly.
corporations.
Yeah. So there must be a reason.
No, I mean, I suppose I'm biased because I know it. I mean, the Washington's corporate law is okay. I could think of some other jurisdictions which may be um, preferable, like a Texas, for example. But I don't think there's a lot of magic to it, and I don't think. But most of my clients these days are starting as Delaware corporations. One argument for that too is all corporate attorneys kind of need to know Delaware law because it is so commonly chosen. It's kind of the neutral jurisdiction as far as anything business related. And that assists with financing efforts because if you're a Washington corporation, but you attract a lead investor who's headquartered on the East Coast or something. I mean, their attorneys probably don't know Washington law, and unless they're a very big firm with kind of some Washington attorneys as well, they don't have the expertise to go and run that down. But everybody knows Delaware. It's kind of a way to not limit yourself as far as the kind of investors that you can attract.
That's a great tip. Um, Wasia, do you want to ask your question yourself? And then I think we should continue with your presentation.
Also, I just had one other thing to add for other jurisdictions.
Oh,
There,
yeah.
there are some jurisdictions where it's a little bit more private, so it's a little bit more opaque as to who the owners are. So I've had clients choose, say, Wyoming, for example, just because they don't want people to be able to readily search who owns the entity itself. Um,
Mm.
there's reasons why that's kind of going away,
Right.
kind of outside the scope of this meeting, but I've seen clients do that for privacy purposes, but that's typically not for high growth startups.
I agree. I mean, you see it for like real estate holding companies, like family equity types of holding companies, lots of Wyoming and Nevada, it's harder to find out who the ultimate owners are of those types of things. So if you're very sensitive about kind of your information being public, those are attractive jurisdictions.
Great. All right, Wasia, do you want to ask your question and then we'll continue?
Sure. Yeah, so I have the patented device with my Indian company, and 2 years back, I started a US entity in the hope of raising funds here. So I want to transfer that to this company, the rights of that device. So what agreements do I need to be prepared with before I go to investors?
Are these entities connected somehow? Are they?
Yeah, I'm the founder and like the owner of both the companies. And I have one person as an equity, one other person as equity holder in the Indian company, but the US, I have not added anyone yet.
Yeah, I mean, this is the oh, go ahead, Steven.
I was going to say that's actually a perfect segue into our next slide, which is about intellectual property.
Perfect. Let's just so hold on to your question.
Okay.
And Adam, if you guys want to continue or answer, however you guys want to go.
Yeah, I mean, I think that the brief answer is that that's somewhat complicated. I think probably you should talk with somebody who can take a look at the structure and your specific concerns. It doesn't sound like you have a current kind of parent subsidiary relationship established between these two entities, and there may be reason to do that. We have lots of clients that have kind of a US parent with an Indian sub.
Yeah, it's the other way around for me.
Oh, is it? Yeah, I mean, we see that sometimes too. But yeah, there may be reason why you don't necessarily need to assign the patent if it exists in kind of a affiliate entity.
Okay.
So let's move one slide forward here. So I obviously for most clients I talk with, the intellectual property considerations are very important. It's extremely important issue for investors and ultimately for acquirers. IP related disputes. I mean, I suppose kind of the classic is a founder who had the critical idea, but never adequately assigned that IP or technology to the corporation, and now they've left the company and they believe that they own the rights to the IP, not the corporation. And so that's kind of it spells doom right there when there's disputes like that. So we really need to make sure that any intellectual property related to this company, there's some document we can point to which says that's the thing that that put that intellectual property and assigned it to the corporation. There's also kind of two periods of time we're thinking about when talking with founder teams. There's as I think it was Ram who mentioned, but it could have been somebody else. Often there's a period of time kind of before the corporation is formed where there's intellectual property relevant to the business being generated, whether it's kind of the business plan or some actual software development, prototype development, ideas, maybe even kind of development of some marketing or presentation materials, things like that. Things which once you form the corporation really ought to own those things. And so we want some document which assigns all of that kind of related but pre-incorporation intellectual property, which assigns it to the corporation. And then we want something too which clearly states that kind of anything the founders or any other service provider does relate, or creates related to the business of the company is going to be owned by the company, including any relevant IP rights. And there could be exceptions, but generally anybody who touches your business should be signing something that says something like that. What they're creating is going to be owned by the company and exclusively. So, I mean, so we help with these agreements. We help with both types. There's, they come by many different names, but often something like a founder IP assignment is part of an organizational document set to kind of assign to the company any pre-existing stuff, and then usually some sort of go forward document which captures any future IP which is developed, and that's called confidentiality and inventions assignment agreement, or any of 5 other kind of similarly titled documents. So we help with those, and these are generally us, especially that latter document, just creating kind of forms of, which hopefully the client can then kind of tailor from person to person. It's usually inefficient for companies that are going to have many service providers throughout their life for us to go and tailor each of the documents for every person. I don't have a lot of clients that want to pay us to do that, and most firms don't. So I think it's more us supplying forms and educating the client on how to go use those moving forward. NDAs, a similar vein. I think every company fairly quickly needs to have 1, if not 2 forms of NDAs kind of in their depository to be used in advance of conversations where they're disclosing sensitive information, confidential information related to the business. Usually if you can only have one, kind of a mutual, which would protect the confidentiality of both parties, or a one-way if you just need to protect yours. And I mean, this could be, I guess we do have some clients that just go overboard. This isn't necessarily something you're using with each like employee candidate in advance of employment, but certainly any critical vendors that you're talking to, software, potential software developers that are going to be really privy and have hands-on to some of your tech, including before the engagement even really begins. Liberal use of NDAs is good there. We generally supply those forms. You can find lots of forms online as well.
I wanted to touch base on that because the NDA is a very interesting point, non-disclosure agreement, because my sense being around the angel investment world, a couple of things is kind of like the common truths, right? The things that people say. And I just want to mention them on video and also validate either truth or non-truth of these things. Number one is they're only worth your ability to enforce them. That's number one. So usually they're not worth the paper they're written on. And number two is that investors do not want to sign NDAs and kind of look down upon that. And so maybe you can address both of those points and kind of like what to do about that.
Yeah. Let me slightly disagree with the first and completely agree with the second point you made. So as to NDAs kind of only being worth kind of your ability to enforce them, that's obviously somewhat true, especially if you're kind of opposite a party that has kind of all the resources and leverage. If they want to steal your confidential information and misuse it and kind of dare you to come after them, that happens from time to time. But at least having the NDA there, it's a signal of intent at the very least, which is probably more than the worth of the paper that it's written on. So I think being clear about your expectation that yes, the confidential information that we're providing to you, we do deem it to be confidential, and you are promising not to, to disclose it without authorization. And even if you're kind of interacting with a liar, at least you've made that known from day one. So maybe that's
Fair
just
enough.
maybe.
And there somebody else is asking, what is a subscription agreement specifically?
Subscription agreement is one of these documents which conveys equity to the subscriber. So usually, I mean, subscription agreement kind of tends to be in future voice. I'm agreeing to purchase 100,000 shares of the corporation at a penny per share or whatever the value is. And generally, when we come across them, I mean, the date that the subscription agreement is signed, that's the date that the corporation is kind of also issuing the shares to you. But it's another, it's another name for any number of document titles, the purpose of which is to get equity into somebody's hands. You'll also see that title kind of in context with like fund. If you're going to be an investor in a fund, usually subscription agreement is the title for the document where you're committing, a certain dollar amount as your kind of, fund investment or your fund commitment.
I also want to encourage people who haven't seen several previous workshops this year. There's a great workshop on what angel investors need and want, and Angel Investing 101, which was really excellently done. So I want you to kind of, if you are building a presentation or just trying to raise capital, it is really critical that you understand what those who give you the money want, right? So as I like to say, if you're raising money, the investors are your customers, and the product is the company itself, right? Because all right, keep going.
Sure. Very quickly, because this is the right audience for it. I mean, as far as NDAs and using them with investors, I would suggest do not do that. Do not even ask for a potential investor, and especially not kind of a venture capital firm to sign an NDA. I think it's going to flag kind of your inexperience in this area. If you're particularly concerned, I mean, you can limit what you choose to share, especially kind of upfront, and let your more critical information out, either as requested or as kind of you've built up a relationship with the other side. But investors are not inclined to sign them. It's not traditional for investors to sign NDAs. Really, you shouldn't do it. And I'd say the one exception is we do see some financings where like a lead investor, a venture capital firm, I said that incorrectly, where the lead investor is going to be like a strategic company, and part of the investment is like some sort of business collaboration. And so you're kind of both looking into each other's confidential information to figure out what that collaboration looks like. There, maybe an NDA is appropriate.
All right, there is a follow-up question I think that is very relevant. Amrit says, well, why not? Is it because the industry is more of an honor system? Why don't you address that if you can?
I think there's an element of that in a way, but I think it's more one's a practical consideration. I mean, a lot of, especially venture capital firms, they're getting a lot of people sending them requests to look at their company. And this is, if they have to go and review an NDA for every company, they're just never going to have time to do what you want them to do, which is to look at your business with the thought of potentially investing. And I think too, especially for kind of serial investors, whether VC or angels, they're looking at a lot of different companies. They don't want it to be alleged against them that that the good idea that you disclosed to them, that you betrayed them and shared it with some other company, because it's more likely than not that the other company came up with it independently. And so I think some investors see, if they sign an NDA, they're kind of painting a target on their back, which they don't want. They want to freely talk with any company that they want. It's not their intention to be nefarious. If they were, they wouldn't be good investors.
Great answer. All right, let's keep going.
Okay. I think we basically knocked out the IP.
Yeah, you guys covered that I think really well. I just wanted to mention one more thing, is that there is a great value to hiring professionals to file and create your IP documents, and there are different options you could do. There are lawyers and there are agents, IP legal agents, but it's really critical to do so. I happen to have a patent, and the value of the patent decreased dramatically because of one word. I used the wrong word, one word in the patent. And so even though it was issued, it was not very defendable because of one word. So it's very important to get the right advice. It does help to do it, do it yourself. It's very noble, but I think that there are places where you don't want to be penny wise and dollar stupid, and this is one of them.
Yeah. Yeah. A lot of what we talked about on the prior slide is relevant regardless of whether you plan to, submit patent applications or try to receive patents. But that's a good point. I mean, I would say we do see, I mean, I come across some kind of do-it-yourselfers. I work with a few who kind of like to take a first pass on a patent application and hand it off to us or their other outside patent counsel. And sometimes that's actually not such a terrible approach because it puts kind of as much information as the client knows down and lets the patent attorney or agent go and kind of run with it.
Yep.
Okay. Steven, I think this is you.
Yes, sir.
All right.
Yeah. And to kind of reiterate that, we've talked about what you can and can't do yourself. I would say equity issuances and intellectual property are places where you absolutely want to consult with professionals and make sure that that's ticked and tied, because we'd mentioned before, those are going to be some key places that investors or acquirers do a lot of diligence and really dig in and look at everything. So you want those ticked and tied. That being said, service provider agreements. This is another thing. They can take many, many different flavors. I mean, you'll have throughout the life cycle of your company many different kinds of service providers, consultants, independent contractors, employees, board members, even independent board members. And all of those people should absolutely have some kind of written agreement that between the company and that person, whether that's just an IP assignment for independent contractors, whether that's a services agreement or a consulting agreement, or for employees, offer letters, or later on for executives, maybe actually a fulsome employment agreement. You need to have some kind of written evidence of their engagement with the company. For those independent contractor consulting agreements, they don't need to be particularly fulsome. They don't need to be 20-page documents. You really just need them to establish the services that are going to be provided, how those service providers are going to be compensated, whether that's cash, equity, et cetera. And those confidentiality and IP assignment provisions are especially important for independent contractors and not employees. The law is not on your side as far as presumptions. Any intellectual property that a independent contractor creates, if you don't have these assignments, is kind of presumed to be theirs rather than yours. So it's very important to have those IP assignment provisions locked up for independent contractors. For employees, offer letters. This is another place where it's good for an attorney to just kind of go over your form, and you can kind of tailor it yourselves. And they don't need to be, again, super long documents. These can be 1 or 2 pagers, just an offer of employment, a loose summary of their job title or responsibilities, who they report to, kind of description of their role, then their compensation as well. So, their annual salary or their hourly rate. And then if they're getting equity, kind of outlining that. And to circle back to the equity issuances, this is a point that we run into as far as cleanup things, where founders will come to us a year or so into their company, their life cycle, and they show us 6 different offer letters that all offer different kinds of equity, or some promise a percent of the company, some promise a certain number of shares, and that can be a huge headache to kind of go back and untangle and actually give people what they were promised. And it can put you in kind of a sticky situation where you have to maybe walk back certain promises you made, or you maybe promise something without fully understanding what it was you were promising. So this is somewhere where it's absolutely worth kind of consulting with an attorney and making sure that what you're promising your service providers is what you actually mean to be promising, and also that your service providers are getting what they think that they're getting, because that's a very common point of contention and dispute early on.
Yeah. Sorry, Stu, I wanted to mention, I mean, it would be common, and this is the case for most of our clients, like we're not getting on the phone with them each time they're preparing an offer letter or considering granting equity. I mean, usually we're talking about a plan up front that they can then go kind of execute. on themselves without having to call us every other day. And so probably the first couple rounds, the first couple offer letters, we'll try to kind of review carefully and figure out, what we're doing. How are they thinking about how they're offering equity to employees? What actually are they offering? Is it a stock option? Is it something else? And how are they thinking about, how many shares are subject to that option? But once we've kind of agreed in principle on a plan, they can run with that quite a ways, and we'll generally check in with them and make sure that it's going to plan.
Yeah, so like Adam was saying, when you consult with attorneys about kind of your initial document set, one of the questions they should be asking you is kind of what is your plan as far as engaging service providers? Are you close to hiring employees? Do you have consultants that you're thinking about talking to? And then you kind of come up with a plan from there, and usually we'll provide form documents kind of off the shelf, tailored to those situations that you're talking about. And then you can, like Adam said, run with them from there. So that this is a place where it doesn't necessarily need to be overly complicated, but it's also a place where it can be an absolute headache to clean up if you don't kind of tick and tie early on.
All right. Similar vein, I want to be very brief on this. Obviously, every company has its own needs as far as its vendors and its customers. I just wanted to mention it that, some thought should be put into how am I engaging vendors? Do I need something that looks like a generic kind of vendor agreement or master service agreement where I'm getting vendors to sign this thing? A lot of large vendors have their own forms, right? That they'll expect you to sign as well. But I don't think it's bad to have something in your pocket where a small software development, consulting firm of like 3 people, they don't have their own form. They're kind of looking to you. So having something that is the document you use to engage that service provider becomes useful. And hopefully that's kind of a fairly general form that an attorney or someone can provide you that you can tailor from vendor to vendor. And then on customer side, again, depends on what type of company you are. If you're a service company, maybe this looks like a master service agreement. If you're kind of a SaaS-based company, maybe this looks like the terms and conditions or terms of service on a website. And so at some point, perhaps closer to the point at which you actually have customers, you should be thinking about what is the document that I'm using to kind of engage them and have them agree to whatever the critical terms are. And I assure you, there are some that you're probably not thinking about, to limit your liability in certain ways, to if you're a SaaS company, to provide them a license to do something with your software, but also places restrictions on their ability to use that software, for example. So I mention it here only as this is another document we're frequently talking about with clients, and you should be thinking about at some point. I think not present in this presentation is kind of financing documents, and that's because we do, and I think we have within the past 6-8 months done kind of presentations on different sets of financing documents, different ways to conduct financing. And if we have time, I'm happy to kind of go into those, but that's certainly another legal exercise that we're frequently tasked with, is kind of discussing financing strategy. What form is this financing going to take? And then preparing the actual documents to go and execute that. I think that kind of brings us to the end of the prepared materials. Let me revisit with the chat for a moment.
There wasn't any more questions right here,
Okay.
but I am, this has been a very highly informative, very data rich presentation. So I'm sure for those of you who are new to this, it might feel like you're drinking from a fire hose. But it's really important to highlight the fact that you are. That is, it's really important to get it right, even as you're still figuring out your actual company and what it does for a living. But yeah, let's open it up for more questions or comments.
A couple of resources as far as document. I mean, some very large firms, especially that are kind of those firms that are known in the space for startup work. And Cooley is the one that kind of comes top of mind to me. But a lot of these firms have document sets that they make publicly available. There's always kind of the asterisk there that you know, like these documents are only as good as the inputs and thought that kind of goes into you know, using them and tailoring them for your company. But those types of resources are out there. So if you type in something like Cooley Go, organizational documents, they have a pretty good set. Perkins used to, and I don't know if those are publicly available anymore. And there's several others.
I have a quick question about the use of AI
Mhm.
to help advise or create documents or assist in documents or assist in analyzing documents. I have a kind of an interesting side story about that, but what are your thoughts?
I mean, there's reason to be cautious, but I mean, we're in the startup and VC space, so in general, we like risk taking, and AI is where there seems to be massive rewards to be reaped. So I'm not shying away from AI. My clients certainly are, and I think you just need to be cautious with how you're using it, especially around you know, data sharing types of arrangements.
Well, I was more
I
thinking in terms of designing or analyzing legal documents.
Yeah, I can chime in a little bit. I've looked into this a fair amount. I think AI is a really good tool for lawyers, especially, or for whoever you are, to kind of augment your own skills and knowledge. But I wouldn't say it's to a point where you can use it to, say, replace somebody else's skills and knowledge that you don't have. So we can use them, say, to kind of, you know, analyze documents, and I know where it's hallucinating because I have the expertise to kind of spot those points where it's convincingly wrong, per se. And I think a lot of software engineer friends I know kind of have similar inputs where they'll have, you know, a chat GPT or somebody spit out some code for them. And to me, it would look great, but to them, it's just not good at all. So I think AI is a great tool if you kind of have a foundational understanding to kind of spot where it may be hallucinating or maybe, again, giving convincingly wrong answers. But I wouldn't say it's quite to a point where you can rely on it to replace your service professionals.
Yeah, I would agree. I have my story really is about I had a contract agreement that I was presented, and I just I put it into ChatGPT, and I said, pretend that you are an employment lawyer. Give me give me your analysis of this, 7-page single space, 10 font or 9 font document with all of these restrictions and alignments. And as you know, I'm certainly not the one to read small print. And it broke it down, and it showed where things are according to industry standards, where it's less, where it's more, what to ask for. It really, with several other inputs, clarifying, drilling down, it really helped me make a very solid negotiation that was much more informed than I could have ever been otherwise. So here's a good, but I think that it would also work for if you are receiving a legal document or from your lawyer, or vice versa. You're receiving document from a supplier or an investor. Run it through ChatGPT, and it might be hallucinating, but you could figure out something that you might be missing.
It's also a good way to kind of be more efficient with your time with your attorneys. So instead of spending 2 hours going over the basics of an agreement, running it through an AI software or something to summarize can give you kind of a better understanding to have questions to have from the get-go. So it can save you time and money that way.
Yeah. There are a lot of resources being put into putting attorneys out of business and or to shorten kind of the reliance
The
on
billing
them.
cycle, the billing cycle, yeah.
Yeah, the tools I've interacted with are they're better at summarizing than they are at creating language. The main way I've been using it lately, I use some summarizing tools, but I use kind of some prompting types of software to come up with provisions that I'm used to drafting, but maybe there's something unique, and so I'll ask it to draft a provision that's a bit more custom, and it just kind of I am very infrequently. I mean, I don't think I've ever copied and pasted something like that, but it'll just kind of help me think about how I want to craft this, this provision in this agreement. So I use it for ideas, I guess.
Yeah.
In drafting from time to time.
Mm.
But yeah, I mean, a lot of attention being paid to be efficient with legal and to also help law firms be more efficient, which is important too.
Yeah. And even AI, like right now, we're doing this Zoom, and I have an AI companion, and it's transcribing it, and I'm asking, summarize what are the important points, what are questions that I can ask. That's another reason. That's another thing that I would love. I love to use, and I encourage people, especially with lawyers, is my favorite question to ask. What are the questions that I didn't know? Or what are the questions that I should ask that I am not asking, right? What can I, and invariably it provides me questions that I was like, yeah, like, I definitely should ask that.
That's a good
And
idea.
I think that that's a really good use of that in legal space, in my opinion. Any other questions, comments, anything? Brian, you came out to check out how Adam does his thing. Maybe you have some insights, inputs into this.
Nothing to add, really. If I were giving this presentation, I would have given the same presentation. This is covering all the key issues, and they were covered very well. I mean, I know that founders have to worry about this stuff a lot, but founders also have a lot on their plates. So this sort of presentation helps lower the worry level, and that's the most important thing. So kudos to you two, or you three.
Thanks, Brian. That's well said. Yeah. Well, happy to hang out for a little bit.
Yeah,
Question?
maybe you could finish up your part by talking about how do you guys do business? So if somebody wanted to employ your company, your law firm, like what is the process, and how is it same or different from you would otherwise go about it?
Yeah, I mean, how kind of what's our deal with startups in particular?
Yeah, like how would you?
Yeah. So I mean, I guess I'll start by saying we've toyed around over the past 8 years with flat fees and found out that doesn't work in this space well. Each company is unique, and getting them organized, I mean, it's easier for some companies than it is others. And I'm thinking particularly of kind of, let's say, a 3-founder team who have pretty strong opinions on things like equity and wanting to kind of carve out IP to be used for some other activities. I mean, that's already much more complicated than kind of the single founder. I'm just getting this thing off the ground, and it's just me right now type of scenario. So I mean, what we try to do, and we have a lot of flexibility on this, but as far as kind of the financial deal, we have the ability to kind of defer a portion of fees until kind of a first material financing event. We have the ability to discount rates similarly until kind of a first financing event. So kind of first, whether we define that to mean kind of a first financing about, where you raise 200K, or we call it kind of the first kind of like a Series Seed or a Series A type of priced round. At some point, we're going to get kind of caught up and kind of back to regular rates, and it's a mutually beneficial thing. I mean, while a lot of clients are interviewing me, I'm interviewing them as well. I only have so much time in a day, and I want to work with clients that are, that are serious about getting things done, and that are serious about paying the fees. So I think that's fair to say. Obviously, I enjoy the work too, but there's kind of the practical considerations of running a law firm.
Well, that's great. Thank you. I actually want to highlight that for those who are listening as well. The pros and cons to hiring a larger law firm like the one Adam is heading, as opposed to an individual kind of like hang your shingle, lawyer, be they great or not. Larger larger law firms, in my experience, have more flexibility they might be more expensive, okay, but they also have a lot more flexibility to defer some of the costs until, as Adam said, some kind of an equity event, which ultimately frees up capital up front to actually get to that event. So sometimes it actually pays to pay more, not just for the quality of the work, but also for flexibility of payment. So that has been my experience with larger companies, because what they're doing is they're very careful at who they pick. Just like Adam says, they're interviewing you, and then they're also bought in to your success, right? They're part of their fee is dependent on the company getting funded. So I find that to be one of the best use of funds in this area.
Just maybe it might be helpful to touch on just kind of the logistics of how that engagement kind of starts and continues and grows. Typically, it'd start with just an hour-long conversation where we kind of interview each other. We kind of find out your goals, where you're at, maybe what documentation you already have in place. And then we kind of have a conversation about the path that you want to take and how we can help you. Whether that's through, drafting documents, whether that's through kind of making introductions to our network as well. It really does vary kind of company to company, but it's usually a conversation that just kind of figures out your needs as we go and how we can help.
That's awesome. All right. Well, I think that's as good a segue as I can make for the end of this presentation. But I want to share with you that I want you to go to seattleangelconference.com, check out all the other workshops that we are having going forward, on the meetup page, which is, I'm assuming, where most of you found it. And there is a SAC conference that is happening the 27th, actually, which is my way of explaining it is, if you are a startup, you want to join the SAC conference because you get a chance to compete for $200,000 in investment from SAC. And if you're an angel investor, so you're a qualified investor, it actually is a great idea. And if you're starting out especially, it's a great idea to join the SAC as an angel investor. You would put in $5,000 plus the fee to be part of the cohort, and then SAC educates you. The whole purpose of SAC is actually to train angel investors. The secondary purpose is to find good investments, but the number one purpose is to educate angel investors and also to have investors meet. So in addition to having several winners in the last 8 or 9 years that they've ran this, SAC also spun off several other investment teams or investment groups. And so that is one of the great values, is that the people who run SAC are basically the graduates of the previous SAC. And so you kind of teach the teacher or train the trainer sort of element. And I find this to be unique, incredibly unique in the world of angel investing, as well as very, very smart. So I highly encourage you, if you are an angel investor, to become one of the angels for SAC. And if you are a startup, there's no better way to kind of get your feet wet by getting exposure to 40 or 50 people. And also, may I add that even if you don't win, very often you will get a sidecar. Someone believes in you enough that they believe in you, so they will invest in you separately from Seattle Angel Conference. So that's kind of my pitch for Seattle Angel Conference. All right, any parting words, guys? All right, well, in that case, I'm gonna stop the recording.